Hello, fellow Toolboxers. Welcome to episode number 380 of the Immigration Lawyers Toolbox. It's a top 10 episode, top 10 things I've learned, which is supposed to be published like in February. Now it's May when I'm doing it, but it's going to be more than 10 inside. The subject's going to have more, so it's really like top 25. But it's going to be a good one. A lot of information you really need to know. So definitely listen to the full episode. Just a lot of things that I want to share about practicing immigration law in 2025 so far. Before you start, some housekeeping. I'm going to be at the ALO conference this summer in a month or so, and I have a booth there for the Immigration Lawyers Toolbox. So please come check it out, take a photo, talk. Look forward to meeting you in person. That's going to be a lot of fun. ALO is always a big bash, and so I really recommend everyone come if they can. There's always so much. And of course, we're going to have a lot of the people that work with the toolbox, a lot of the sponsors there, in particular, Serenade, eImmigration. Y'all know they've been talking about a lot. They're doing a lot of updates and new software coming out in AI. They're going to be doing a big announcement there with a new partnership. But I do want to mention their help because they sponsor this episode and the upcoming magazine that's coming out. It's a real good one. Speaking of the magazine, if you are interested in getting published and having your content out there, get your name out there, both to help promote the industries for colleagues to get better, kind of the work we do here, and also just help your marketing as well. We do publish your articles. We just want something that's helpful. So if an immigration lawyer reads, it's a higher standard. And that's not for the public, but if an immigration lawyer reads it, like, oh, that's a piece of expertise that I didn't have that I picked up. So if you have something like that, hit me up. We're trying to do 4 magazines this year, so publish quarterly. Eventually do monthly, who knows? But we got a lot of articles for this one, so I'm not sure if we get you on the next upcoming one, but get in early and we get you on the next one coming up in the fall. But that's Immigration Lawyers Toolbox magazine. If you haven't read it, the new issue is out, issue number 9. Real good stuff in there. We're going to be starting to interview a lot of the authors and colleagues who publish. So it's going to be really interesting. But again, thanks for Sarah's Immigration. If policy whiplash and mounting caseloads are draining the joy from your practice, you're not alone. You became a lawyer to help people build new lives, not to drown in paperwork and rework cases amid shifting political winds. Don't you know that? That's why the experts at eImmigration by Serenade created the Certainty Factor, a free guide showing how to purpose-built AI tools can create stability in your practice without sacrificing the human touch. And AI is the big thing. Is really, if y'all haven't seen the AI of Google creating videos, it seems like Hollywood is done this toast. I don't know. That's kind of crazy. Featuring insights from top innovators in immigration law, we're sharing ways to implement AI so you can be a strategic advocate again. Download the Certainty Factor today at eimmigration.com/certainty. Again, that's eimmigration.com/certainty, and put the heart back in your practice. At get.eimmigration.com/certainty, or find the link in the show notes, and we'll put that there so you get to know. Heads up on it. The AI system is going to be taking over everything. So the sooner you join them, that's better than fighting it, because it seems like it's coming like a freight train downhill. So I want to thank them. Also, with regard to the Toolbox, we have our marriage immigration course. We got a lot of new students. There's 15 plus hours. Mentorship is the key to really put you in the spot to have your own practice or to grow your own practice. And along with that, we do a lot of other courses like E2 training and the like. We're having a big private course we're doing for a firm about EB1A extraordinary ability. And because I've ready to go with them, we're going to make that into a course. So if you want to get involved in EB1A extraordinary ability cases, primer, we're going to set that up and have that ready. So email me at info@immigrationlawyerstoolbox.com if you're interested. But we have a lot of free stuff on that helps as well. On the community page, it's for lawyers only. I have like AEO decisions that I reviewed, and you learn a lot about practicing in this area. I just did one on the 3 dancer cases that were submitted to the AEO in December, January, February 2025, or December 2024. And I reviewed why they were denied and see the overlap. So it's very educational. It's a free CLE type of thing on our website, plus the CLE on L1s, on 245I. All this is free content for immigration lawyers. Just email me and I'll add you to the group, info@immigrationlawyerstoolbox.com, lawyers with the S, and you can check that out. And so that's the big news happening with regard to housekeeping. But let's get started with the craziness of U.S. immigration law. So the big news for me that I have a USCIS practice, I mean, the big news is really people being picked up at the courts and all that kind of stuff, and the potential bill that's coming that's going to charge a bunch of money in filing fees and increase the ICE apparatus, which is eventually going to be turned on American citizens. I'm 100% sure of that. but having said that, the biggest thing that affects me in my practice is the amount of interviews all of a sudden that came up. We almost have like daily interviews with USCIS for our marriage adjustment cases. And you can see that in certain rooms. Certain offices just don't get busy, but certain ones get really busy in LA, especially. So expect busy rooms, but also, unfortunately, we're seeing workload reduction happening where they're giving money for people to retire with USCIS, and a lot of people are picking that up, and also with the judges. A lot of good judges are leaving because of that. So be mindful of that. There's gonna be lines outside some buildings now. Like I go to Chatsworth in downtown LA. That's the primary ones I go for immigration interviews. The Chatsworth or San Fernando Valley office is normal, but LA, there'll be lines around the building. So you got to get in early. Just be prepared for the local field office you're sending clients to, you're going to go to, and arrive early. And what's different in the interviews I'm seeing is like there's a lot more questions about bona fide relationships, even when it's really obvious they're a couple, but they just go into detail. But the disturbing thing was just asking about have you read political statements on your social media on this, on that, and that's a thing that's obviously new with the drama that's going on. But unfortunately, that's what the new normal is. We're going to be asked about political thought and thought policing when it comes to immigration process, and hopefully that hand turns back. But that's where we're at right now. Number two, practice alert. The CIA Ombudsman's office has been taken down. The CLOIDO office closed. I don't really deal with the latter two, but this USCIS Ombudsman shutting down was a nightmare. Because we use them a lot. There's a lot of USCIS error going on with the lockbox, and they've been helping just get a hold of the lockbox and fixing that up. We had a lot of cases, like not a lot, we had like 3 cases in the last 3 months that had lockbox issues, and the Ombudsman was helping us until the day that they stopped, and the last second they helped finish up one case where the lockbox just incorrectly kept rejecting the case. But that's a disaster right there that they were shut down, and we're also seeing. I'll get to that later, actually, for I-290B. But they were really helpful, but unfortunately, they're done, and I'm not sure if they're coming back. And I think essentially the USCIS Ombudsman and the 2 offices are the same for EOIR, those kind of cases. So I'm very sorry to hear that, but that's the situation. Next, this is kind of just informational. There's this form called N470 where if you're a green card holder and you want to be outside for extended periods of time, if you're doing certain work, like for national organizations, international organizations and stuff, you can potentially avoid breaking your continuous residence. So that's a good thing. You can maintain that and still come back without them denying your citizenship if you satisfy the physical presence requirement. But if you're doing a religious worker N470, there's an exception where that not only does the time that you're abroad be counted towards. Wait, am I writing that right? That was the main thing I want to see about that is that. Typically for the N470, you have to spend 1 full year in the United States, a continuous period of time, before you can file for the N470. And it's almost impossible because people have green cards that are constantly traveling internationally, so it's just hard to satisfy that requirement. Now, we started getting a lot of these cases after the pandemic because the pandemic forced people to be in the U.S. for a full 1 year, so it took care of that criteria that almost all the consults we had on it wouldn't have. But I had this religious worker consult, and I looked into it, and it's interesting where for religious workers, they don't need to satisfy the 1 year requirement presence before filing the N470. They could leave and file it even. But before they apply for citizenship, they have to satisfy it. So essentially, they travel, do all that kind of stuff, and then once they come back, and they'll be able to spend a year here in a continuous period and then file for N470. Now, if you read the instructions for the N470, it improperly implies that the religious worker is totally exempt from this requirement, the 1 year requirement, but it doesn't go into details. But when you go check out the USCIS policy manual, volume 12, part D, chapter 5, there it breaks down like this thing. So I was really confused when I was reading it. It's bizarre. Everything's so nuanced with immigration. All right, number 4 is Form I-290B in case of incorrect adjustment of status denials, either on like the I-864, like they just made a mistake, you did it correctly, or what we're seeing is people responding to RFEs, or notice of intent to deny, and then the government denying the case saying we don't get your response, even though there's tracking on it. Now, typically we would contact the USCIS Ombudsman's office on this to try to fix it up quick, or contact the USCIS field office, some form or fashion, email, letter, whatever, to say, hey, this is an error. I don't want to do an I-290B. But that comes to the last resort. Sometimes we got to pay that extra money to them to do a motion reopen, reconsider. So these are happening a lot, these kind of denials. We're getting both colleagues telling me about this and seeing posts on it, and people contacting me about it. But also then we're seeing that I-290Bs are being denied, saying you haven't argued a new fact or law even though it's clear USCIS error and they have proof of it, they're still denying the I-290B, and then people are getting stuck. It's like, what do you do there? So be aware of that, especially because the I-290B does not keep you alive or prevent an NTA from happening. People unfortunately think that if you file the I-290B, you're not accruing unlawful presence and they can't do an NTA, notice to appear, for immigration. Of course, not the case. Now, if the I-290B is reopened, it's almost like a nunc-pro-tunc where they clean it up behind the scenes. But it's not a thing that you could rest assured that I-290B is keeping you protected. So be aware of that because I've seen that bad guidance happen before. Number 5 is regarding reentry permits from I-131. They updated the form. It looks longer, but it's actually shorter. One of the requirements of explaining what your traveler needs are for the I-131 are gone for reentry permits. I was surprised about that. It's just the first couple times you do it because it's a new form, it's longer, many more pages. I was like, oh, it's gonna be a ton of more work, but it wasn't. It's actually much shorter because the way it's designed. Number 6 is the medical requirement for getting a green card. The one is the COVID vaccine requirement was already taken off from USCIS, but they also took it off for immigrant visa processing at the U.S. consular office for you doing immigrant visa processing at the embassy. So that's that. But also on the other side of it, they added a polio vaccine requirement, even if you had it before. I think it's been a year now. And so I was at the interview. I just went to USCIS, and the officer told me we're issuing a bunch of requests for evidence for people that the doctor wrote that not age appropriate for polio, but there are things that you got to do it. And then they give you 30 days. So people got to jump and get that. And then there's the issue of mailing it back. And will the post office lose it? Will the lockbox not get it? So all these disasters are there. But hey, polio, who'd have thought that's back, and you got to get the vaccine for it. Number 7 is embassy registration. At the U.S. Embassy in Nigeria and London, a bunch of other places. What they're doing is instead of having you come to an interview and review your documents and do the immigrant visa interview, they're changing it up where you come in one day to review your documents to make sure there's an order, and then if it is, then you come to your regular appointment date for actual interview to talk about your case. In some ways, it makes it more efficient for them, but it makes it hella inefficient for other people, especially like in Nigeria, where people might have to drive like 3 hours or 5 hours to get there to show documents, go back home, and then come back in for an interview. So that's super inconvenient. So be prepared for that. In particular, about Nigeria is we were trying to register an interview with them, and the buttons that you typically use on the online website for consular processing. When I realize most immigration lawyers don't do consular processing, but definitely need to listen to this. If you do, it's going to drive you crazy. The buttons to register didn't correlate with what they're doing. So I can't remember the wording of it, but the options you're supposed to follow to register an immigrant visa appointment led you down like a glitch that wouldn't work. You had to like click on the wrong buttons to find the right one. It was the client found that out because I was like, what in the world's going on? When I'd email them, ask and contact them, they wouldn't tell me. They wouldn't respond. So that was really, really obnoxious. Number 8, I do want to plug an episode I did, number 375. I was going to mention earlier when I talked about 290B, but I did this episode number 375 going over 8 CFR 103 by USCIS filing, top 10 tips of top 7 things you should know about that 8 CFR section. It's really interesting tidbits of knowledge about what works and what doesn't in processing, how to send stuff, how to think about stuff. It's a short one, but it's really practical. Didn't get as many views as I thought it should, but if you're practicing immigration law, definitely listen to it. It's fast, but it's like you're gonna get one piece, a nugget of gold in there. And I'm gonna try to read more of these CFR sections and just get like top 7 tips of it. Again, I don't know why it doesn't get more views on these episodes because they're really helpful. But if you're immigration practice and paralegals listening to, definitely listen to this. You're gonna learn a lot of tips that could be helpful. Number 8 on the top 10 tips for right now, I was going to say this month, but I'm not publishing these monthly, is read the immigration notices that you get. We, sometimes get used to getting approval notices and the like, or receipt notices, and it's just like, you scan it, put it in there. But we just got an EB case where it said the family of a U.S. citizen. It was like employment based, but the approval notice said family of U.S. citizen or IPR, LPR. And I was like, wait, that doesn't make any sense. And we're not going to correct it because it says like, I-140 on it and stuff like that. But it's, it's like, it's just why would it say that? Then we had another case for adjustment that I went to the other day where the person came on an O1, but the CBP gave an H1B. The officer was kind of confused, but I looked at him like, dude, this person obviously an H1B. They didn't need to lie about a visa because they had an O1. Normally we contact CBP to fix it. I'm sure why we didn't do that in this case, or they probably just said, just don't bother us. But it was like, it's not an issue per se, but you got to check all these I-94s every time you come. You never know what they're going to put in there. Like one problem that always pops up is people who have passports expiring earlier than their approval notice date for an employment-based case. And so they don't check their I-94 thinking the I-129 approval notice is how long they have. And then they realize, oh, I've overstayed by 8 months now. And that could be a 3-year bar right there. Now, they do nunc-pro-tunc many times and let you fix it up, but sometimes they don't. So you got to be careful of that. Number 9 is about Social Security Office. Now, they updated most of the change of status, like naturalization and adjustment status and EAD forms to allow you to automatically get your Social Security card issued and stuff. But what we're seeing is that Social Security Office is not necessarily sending out this information, and they're kind of requiring people to go in person to get the Social Security number. I think this is under the Trump administration, Doge trying to crack down on Social Security fraud or whatever that is. But be mindful, we're seeing this issue where people got to go in. As you imagine, there's funding cuts. There's like no one to go into, like talk with or get an appointment, all that kind of stuff. But that is something we're seeing. And then finally, it's about consular processing. A great colleague in Israel, Liam Schwartz, wrote on LinkedIn that the U.S. Embassy Manila office has updated their policy saying starting May 19th, immigrant visa applicants who arrive at the U.S. Embassy for their appointment without all the required original documents will not be interviewed and will need to reschedule a new appointment. I should have put this in the other section about Nigeria and London that have this requirement you separately come. But this one is just saying instead of separating the 2 days, they say if you come, and the Philippines is one of those places where people got to travel sometimes. There's like a million islands over there. But if they don't, there'll be original documents will not be interviewed and will not need to reschedule a new appointment. Be aware the next available appointments may be months from now. So that's kind of annoying. The new policy directly contradicts guidance, and it's what Liam wrote. This new policy directly contradicts guidance for consular affairs interview, even if documentation is missing section. In addition to the inconvenience and expense caused to the applicant and the family, it's generally inefficient for unit to not do that and have them come back for another day. So he writes more about it, but it's kind of ridiculous that that's just the thing we have. On the happy side, I do want to mention that the Department of State has updated its system, not only to update the expected interview times for non-immigrant visas, FB, all that kind of stuff, but a great thing they've done finally, and very appreciative, is that they have a website now. If you type in, IV visa tools or something like that, they list the immigrant visa scheduling time. So if you're documentary qualified, when you'll get a notice for an interview, that notice will have an interview date that's 1 to 3 months afterwards. But it's magic because it really helps you understand which embassies are doing what the timelines are. Because people always ask us what timelines are. And we're like, well, we think it's this, we think it's that, but we don't know. And now we have something that's pretty accurate from what I've seen so far. Some of the stuff's sad when you see some countries taking 3 years to get an interview. Nigeria, again, I'm talking about Nigeria a lot. Pakistan delays and Dhaka and all these kind of countries that. But we had one in a case where we got documentary qualified for England. And on the website, the person within 2 weeks got their interview scheduled. The interview was scheduled for like 2.5 months afterwards. But I checked the website and it was accurate. So I'm like, oh, wow, like some embassies are that up to date. So that was a really cool thing that existed. So there's more to talk about. This matter Q Lee came out. It's not my specialty, but I want to mention you should look into that for EOIR stuff. This pre-terminated stuff for asylum they're messing around with, where if you didn't file your asylum case properly. And then do a bunch of funky stuff in the EOIR, essentially. I'll have to have Kevin Gregg, another expert on EOIR stuff, come and talk about that. But I wanted to share, that's pretty much my practice, USCIS, DOS stuff that we see, interviews, filings, all that kind of stuff. But, check out join our community page on circle.so. We have, again, that free EB1A dance or AO decision review. I have an L1 one that I did. I'm going to do more of these. And also we have the AI where I have AI review all the AO decisions, do synopsis and the job title. So you quickly find, like if you get a NIW case for a scientist in a certain field, food scientist, you can try to look down the jobs list, see if you have a food scientist one in there, compare what's going on in your case, what was issued there, or maybe they reference, certain awards or conferences or things that are positive, things that can help strengthen your case. I think it's really important, mandatory even, if you're doing, this kind of practice, EB practice, EB1A, L1, EB1C. There used to be a lot of L1, EB1C appeals. There's very few of them now, it's surprising. But to study these things, to really master your craft and your practice. So thanks so much for listening. I'll see you on ILA this summer. Please come by. And if you want to get the EB1A course, hit me up, info@immigrationtoolbox.com. We have that popping up, as well as the long-standing and very successful and powerful marriage green card course for those who wanted to take their practice to the next level. I'm immigration lawyer John Castravi. Thanks so much for listening. None of the info provided in this video and recording was intended as individual legal guidance, but you all know that already. Have a good one, everybody. Bye-bye.